Hi everyone, I am Ayushi Jain from School of Law, Modi University, working as a legal intern in LEXIS and Company. Today, in this video, I am describing about cybersecurity law in India. I divided this topic in two parts. In this video, I am describing the first part of this topic. The cybersecurity law in India. India is expanding up on the web radar to touch yet another milestone this year, flaunting the second largest internet user based on the stone 560 million users. The pandemic pushed this number further in 2020 this year, as the prediction is come to minimum of 600 million users. But on the flip side, this unconstable figure reinforced the need for the robust cybersecurity framework of the nation. Its constant digitalization and data growth, it's pivotal or to emerge up with the necessary resources, including comprehensive training to ensure data privacy and cybersecurity law in India. Plus, with cybersecurity being a $6.5 billion industry, there is a greater need for extreme and rigid cyber law in India. Increasing attack on cybersecurity system. Cyber crime are recently drawing major newspaper headline globally, causing unanticipated damage across the industry and individual. The predominant form of this cyber theft include data breach, identity theft, financial theft, internet time theft, among others. Though cybersecurity is advancing every day, hackers are also constantly upping their game and finding way to break into new systems. This reinforces the need not only for the better cybersecurity system but robust the cyber laws as well also. Further, to mitigate the cyber crime and to curb the effect of the fluster, lawmakers need to be a burst of potential loopholes in the cybersecurity landscape and fix them in real time. Precedent effect with consent wiggle are crucial to control the essential risks nationwide. Introduction to cyber laws in India. The United Nations Commission on International Trade and Law embraced the model law on e-commerce to spread herd legal uniformity globally in 1996. The General Assembly of UN endorsed this model law as backbone of the cyber law of different countries. Soon, in India become the fourth country to legitimate cyber regulation. Post the initial draft creating by the E-Commerce Act by the Ministry of Commerce in 1998, the revised Information Technology Bill passed in May 2000. Finally, things came under control and anticipate the Information Technology Act back in October 2000. This act intellectually traces each trafficking activity or transact on the internet, cyberspace and World Wide Web. Each minuscule action as well as its reaction in global space imposes several legal implications and penalty angles. The act swiftly amended the traditional set the Indian Penal Code 1860, the Banker Book Evidence Act 1891, the Indian Evidence Act 1872 and the Reserve Bank of India Act 1934. This amendment to tone up all electronic transaction communication, break up then render up by granting the strict legal recognition. Other significant step towards as was accepting digital signature as legal authentication. This had far broader implication cover other tech drive authentication form like biometrics. Further, the popularity of electronic fund transfer and electronic data storage asset attended to the need and the success of the frustrated vision behind the IT Act. Regulation framework of the cybersecurity laws. There are 5 prominent laws covered under this, but in this video I am covering only one. Another 4 I will covering in the next video. We start with Information Technology Act 2000. The Indian cyber law are governed by the Indian Technology Act penned down back in 2000. The principal impacts of the act is to offer library legal inclusiveness to e-commerce, facilitate registration of real-time record with the government. But with the cyber attack getting thicker, topped by the human tendency to misuse technology, a series of amendments followed by the Information Technology Act enacted by the Parliament of India highlights the grievous punishment and penalties safeguarding the e-governance, e-banking, e-commerce sectors. Now the scope of Indian Technology Act has been enhancing to encompass all the latest communication device. The Information Technology Act is a silent one guiding the entire Indian legislation to govern cyber crime rigorously. Section 43 application to person who damages the computer system without permission from the owner. The owner can fully compensate all the entire damage in such case. Section 66 application in a case a person is found dishonest or fraudulent, any act referring to in section 43, the imprisonment term in such instance can mount up to 3 years or a fine up to 5 lakh rupees. The section 66B incorporates the punishment for fraudulently receiving a stolen communication device or computer, which confers a probable 3-year imprisonment. The term can be topped by the rupees 1 lakh fine depending on such severity. Section 66C. The section is scrutinizing the identity theft relating to imposter digital signature, hacking password or another distinctive identical feature. If proven guilty, the imprisonment of 3 years might also be backed by rupees 1 lakh fine also. The last section I am dealing with in this video is section 66D of IT Act. This section was inserted on a demand, forcing on the public cheaters doing impersonation using computer resources. Thank you. The other 4 I will discuss in next video. So stay tuned for the next video.